Welcome back. In this lesson, we're looking at when a trust comes to life. Not revocable versus irrevocable. That was the last lesson. This time, the distinction is living versus testamentary. And the real trade-off here is simpler than it sounds. It's about lifetime control versus after-death simplicity. This is about the when. When exactly does the trust transformation happen? When do you have to start managing it? And when does it start costing you money? Today, we are looking at two very different paths for timing your plan. We are talking about living trusts versus testamentary trusts. This is essentially a choice between starting now or starting later. Let's start with definitions, in plain language. A living trust, also called an inter vivos trust, is created and becomes effective while you are alive. A testamentary trust is written into your estate planning documents, usually in your will or trust, and does not exist at all until you die. Both of these could get the job done, but they have very different impacts on your life now and your family's experience later. Let's start with the path most people have heard about, the living trust. If you would like to learn some Latin, inter vivos is just a fancy Latin way of saying between living persons. As the name suggests, this trust is created and comes to life while you are still alive and competent. When you set up a living trust, you're usually the grantor, the trustee, and the beneficiary all at the same time. This means that on a daily basis, your life may not feel any different. You could still sell your house, spend your money, and manage your investments. The only difference is that you are doing it in your role as a trustee rather than as an individual. This gives you two major advantages. 1, control during life. You can decide how much goes into the trust, when it goes in, and sometimes how it operates while you're still alive. And if you became incapacitated and could no longer manage your own affairs, a living trust could act as an instant safety net. Your successor trustee could step in immediately to pay your bills. 2nd, predictability. Because you're funding the trust with assets you actually own today, you usually know whether the trust can realistically accomplish its goal. If you want to support someone, help a charity, or set aside money for education, a living trust lets you see it working in real time. It could also help your family avoid probate, because the trust already owns your assets. There's no need for a judge to get involved to distribute assets when you pass away. Your successor trustee simply steps into the driver's seat and follows your roadmap. But there's a cost to that control. Living trusts usually require more upfront legal work, more coordination, and more follow-through, especially funding the trust properly. Now let's talk about testamentary trusts. A testamentary trust is essentially a future trust. It's drafted inside your will, but it stays dormant until your death. Nothing is transferred into it while you're alive. Nothing operates while you're alive. It's just instructions waiting to be triggered. In essence, it only comes alive after you pass away and your will is proved in a probate court. Why would anyone choose that? The answer is often simplicity and cost today. Creating a testamentary trust is usually less expensive up front because it is just a few extra paragraphs in your will. You don't have to worry about funding the trust now, which means you don't have to retitle your bank accounts or your home today. This could be a great safety net strategy for specific scenarios. For example, imagine you have young children. You might not want to deal with the administrative tasks of a trust for the next 30 years if you live a long, healthy life. Instead, you could put a testamentary trust in your will that says, in essence, if I die while my kids are under age 25, then and only then should a trust be created to manage their inheritance. If you live until they are adults, you could simply sign a codicil or a new will and remove that provision entirely. It's a way to plan for a maybe without doing the work of a definitely. Another reason individuals may choose the starting later path is because a trust is not free to run. Some people don't want the stress of running their own trust, so they hire others. A trustee can manage the trust, but trustees are allowed to charge fees. If you don't specify compensation in the trust document, the law usually allows reasonable fees, and reasonable can still add up. Professional trustees, like banks or trust companies, often charge an annual fee based on a percentage of trust assets. Around 1% per year is common, sometimes more. On top of that, there may be one-time setup or termination fees, annual administrative fees, accounting and tax preparation fees, extraordinary fees for unusual situations. If you are serving as trustee, you can try to minimize the added expense, but your successor trustee may require compensation to step into the role. With a living trust, costs may start during your lifetime. With a testamentary trust, costs begin only after death, assuming the trust is funded and activated. However, the starting later path has some consequences. Because a testamentary trust is born inside the probate process, it may be subject to ongoing court supervision. This could mean your trustee has to file reports with a judge every year, which could lead to more legal fees for your estate over time. And perhaps most importantly, a testamentary trust provides zero protection if you become incapacitated. Since you have to die for the trust to exist, it can't help you if you are just sick and need someone to help you manage things. So let's compare common planning scenarios. Living trusts are often used when you want benefits to begin during life, you want to reduce uncertainty about funding, You want flexibility to add or adjust assets over time. You want smoother transitions if incapacity occurs. Testamentary trusts are often used when you only want the trust if something happens early. You're primarily planning for specific situations. You want to minimize lifetime administration. You're comfortable relying on probate to activate the trust. So, what's the takeaway? Living trusts give you earlier control, earlier costs, and greater certainty. Testamentary trusts give you delayed complexity, lower upfront cost, and more uncertainty about funding. Neither is better by default. The right answer depends on your goals, your assets, your family situation, and how much complexity you're willing to manage while alive. If you want one small action from this lesson, here it is. Ask yourself this question. Is this trust something I want working while I'm alive, or only if I'm gone? This choice isn't about good or bad planning. It's about when you want responsibility and protection to begin.